There were two ways that it changed. One from the outside was that, I mean, until the 1960s, many schools were very upfront that they had quotas. I remember one medical school said, well, yes, we have a quota, but we don't want our one-woman doctor, our one-woman medical student to feel alone. So we always bring in two every year so that they won't be unhappy. And law schools the same way. At dental schools, there was the head of the dental school, I think the University of Texas in the 60s, said that women could not be dentists because they weren't strong enough to pull teeth. I mean, there was a really strong sense that women shouldn't be doing this stuff. They didn't really want them around. And it was all perfectly legal. You know, it was perfectly legal for businesses to say, as they often did, that this wasn't a job for a woman. There's just so many examples of women who went out and applied for jobs and were just told, well, we don't have women for that. You know, Nora Ephron told me the first time she went to Newsweek and applied for a job, they said, well, women don't write here. They do research, but they don't write. And many of the most famous female writers of our time were told by Newsweek that women don't write at that point in time. And all those things were legal. It was legal to say that women couldn't be in management because it was bad for the men. You know, all that stuff was okay. Or that women got paid less for the same job. That was, people put that on lists. That was not, you know, something that you tried to hide. And of course, the help wanted ads were all help wanted men or help wanted women. And you know, the receptionist jobs were over here and the good stuff was in the other way. So the two ways that changed were, one, in 1964, when the Civil Rights Act was going through, a representative from the South, an 80-odd-year-old, very, very conservative guy, added gender to the things you could not discriminate against in employment, and it was a joke on his part. And I think also it was an attempt to slow down the bill and complicate things. But Martha Griffiths, who was the only woman lawyer in the House at that time, grabbed hold of this and brought her people and added them to the conservative Southerners and actually got it passed. And then it went to the Senate where they were also going to take it out, and Margaret Chase Smith grabbed hold of it and ran through and got a touchdown. At that point, there was virtually no woman in this country who thought there should be a law prohibiting discrimination in employment because of gender. That seems so far out in the future.
Sure.
The women at the Commission on the Status of Women, the most radical women there, were hoping that someday there'd be a study commission on this. Nobody was thinking about this. But then suddenly it was in the law. And once it was in the law and women realized that the government was not planning on enforcing that part of the law, then they went crazy. And that's when the National Organization for Women was founded. That's when women started to go to court to sue. And that was really the beginning on one side of all the changes. The other thing that happened was that the birth control pill came on the market. And although people were discriminating against women, it's also true that very few women applied to law school or medical school or any kind of a job that required a really long-term commitment for preparation back in the 60s and before, because they all believed you should marry very young, because that was the average age of marriage was 20 in 1960. And that once you got married, you know, there was not much you could do to really totally prevent pregnancy. So people were very reluctant to make a commitment to a long-term career at that time.
This excerpt is brought to you by the Massachusetts School of Law, the leader of reform in legal education and a leader in multimedia education for the public. To view the full interview and for a full listing of MSL's programs, log on to mslaw.edu.